Vou começar por me apresentar. Eu sou Juana Cueita, eu sou diretora de programas da Conectas. Eu quero começar por agradecer o convite da Marta para estar aqui e a flexibilidade dela para arranjar um momento em que eu conseguisse participar. Eu falei para alguém que estava comigo no banheiro que assim, minha cabeça está fervendo, porque as discussões que a gente está tendo, elas são um tema de estudo, mas também falam da gente como mulher, como mãe, no meu caso, como trabalhadora e como empregadora no trabalho formal, na Conectas, mas também no trabalho doméstico. E eu me pergunto muitas vezes se estou fazendo a coisa certa e não tem muitos espaços para discutir sobre isso. Não tem muito lugar onde conversar com as mães, como que elas explicam algumas coisas. Eu não tenho espaços para conversar com outras empregadoras mulheres, como é a relação com as empregadas mulheres. Então, são temas que falam sobre a gente com muitas perspectivas. E eu celebro ter conseguido estar hoje aqui. Então, a gente vai começar o segundo painel do seminário, cujo título é Negociando Subjetividades, Instituições, Mercado e Intimidade. A gente vai ter 4 apresentações, seguindo a regra da manhã. Cada uma das apresentadoras vai ter 20 minutos e a gente vai ter depois um tempo para debate, como foi feito na mesa anterior. Então, vou começar por apresentar a primeira palestrante. O trabalho dela é Trabalho Sexual, uma abordagem pós-colonial, materialista feminista. É Prabha Koteswaran. Eu pratico um pouquinho. Ela se juntou ao King's College em Londres em setembro de 2012, onde leciona Direito. Trabalhou na SOAS. Ela fez graduação em Direito na Escola Nacional de Direito da Universidade da Índia, em Bangalore, e é mestre e doutora para a Escola de Direito de Harvard. Ela atua como advogada num escritório em Nova York, e suas áreas de pesquisa incluem direito criminal, teoria legal feminista e sociologia do direito. Ela é autora do livro Dangerous Sex, Invisible Labor, Sex Work and the Law in India, de 2011, que recentemente ganhou o prêmio Hart Book Prize. Ela também coordenou uma revisão sobre trabalho sexual publicada pela Women's Unlimited e atualmente trabalha na crítica da lei antitráfico. Então, você tem 20 minutos para a sua apresentação. Thank you.
Thank you. Thank you so much. My grateful thanks to the organizers yet again for pulling off what is really an incredible feat. So congratulations. So the title for my talk today is slightly different from what's on the program. It's actually The Laws of Social Reproduction, a post-colonial materialist feminist approach. So I was earlier going to speak specifically about sex work or prostitution, but I think many of the insights of my research on sex work apply to other forms of abject female labor. So in keeping with the themes for this first day of the conference, namely women and economy, I thought I'd speak about what I call the laws of social reproduction more broadly. So I have 2 sections in my talk today. In the first section, I'll talk about the need for feminists to rethink social reproduction. And in particular, I want to deal in my presentation with mobilization by women workers to have abject forms of labor recognized as valuable and be recognized legally as legitimate work. So I consider women in 3 sectors, namely sex work, exotic dancing, and commercial surrogacy. So these are all, certainly in relation to sex work and commercial surrogacy, I've done some field work in India, and I've written about exotic dancing in India as well. So although the examples come from the Indian context, I think there are insights which could be translated. Slow down? Okay. Which can be translated in a south-to-south context. In the second section, I want to outline what a post-colonial materialist feminist perspective can offer to rethinking the laws of social reproduction. So moving on to the first section, my impetus to argue for the recognition of the labor of women in sex work, dancing, and surrogacy comes from a rich feminist tradition of conceptualizing reproductive labor. And by reproductive labor, I mean the labor involved in social reproduction, namely biological reproduction, unpaid production in the home, both goods and services, social provisioning, the reproduction of culture and ideology, and the provision of sexual, emotional, and affective services, which are required to maintain family and intimate relationships, all of which are performed predominantly by women, typically within the institutional context of marriage. So demands for the recognition of such labor have ranged from radical proposals such as wages for housework in the 1970s to more recent attempts at the equitable distribution of marital property upon termination of a marriage, to rearrangement of responsibilities for care between men and women when both are in the paid labor market. So social reproduction under the neoliberal conditions of globalization have dramatically shifted the parameters of these debates. So decisive trends, certainly in the West, include women's increased employment, a larger aging population, and declining social welfare, which have resulted in the homemaker breadwinner family wage model being replaced by a dual earner model that seeks to accommodate global competitive pressures for flexible labor. So confronted with the crises that the global economy and welfare states are thrown into, feminists point to how women are not only increasingly being called to perform paid work in and for transnational markets, but they also face increased burdens of social reproduction. And these may be reduced to some extent by the vast inflow of female migrant workers from the developing world, especially for domestic work and childcare. Yet as states are driven by neoliberal thinking to address the care deficit, feminist scholars point out that the gap between the outflows of care and the inflows of care actually falls below a threshold of biological, financial, and affective sustainability. So they're articulating the term of the depletion of social reproduction. Now, the challenges facing the provision of social reproduction are significantly different in the developing world. So for one, the institutions that constitute what has been referred to as the care diamond, namely between the market, family, state, and community, are configured in fundamentally different ways compared to in the West. So in a country like India, for instance, the welfare state is at best minimalist, constituting what feminists call a residual welfare regime. Urban women's participation in the workforce is quite low at 16%, resulting in the family being the privileged site of care work. And where women's work has been commodified, it is to accommodate their familial responsibilities towards social reproduction. The institutional parameters within which the political economy of reproductive labor is nestled and the sort of regulatory impulses are also driven by what feminists call gendered familialism. So there's a very strong notion that care is a familial and a female responsibility, and work in the market essentially devalues these dimensions of care. Paradoxically, however, there's also an increased incidence of sex selection, which then results in trafficking for social reproduction. So moving on to how feminist legal scholars have thought about social reproduction, they've engaged with the law's regulation of women's reproductive labor for a very long time. They have in particular demonstrated the central role of the law in producing and entrenching the invisibility of women's reproductive labor. So the feminist legal theorizing of social reproduction reveals the sheer contingency of the regulatory matrix which governs the family and unpaid housework. So we may currently default to the family law for recognizing women's reproductive labor, although labor law might just as well have mandated wages to housewives. So there are two broad strands of theorizing here, and much of the early path-breaking work on the law's regulation, and indeed the appropriation of women's reproductive labor, dealt with a lack of legal recognition of women's reproductive labor as valuable. So legal feminists reached into the depths of Carol Gilligan's work and articulated a fairly normative view of unpaid reproductive labor or care work, which is reflected in a range of legal proposals. And here feminists have pointed to the significance of legal rules ranging from family law to tort law to welfare law to bankruptcy law, tax law, and so on. Now, there are other legal feminists who have increasingly focused on theorizing care in terms of redistribution, especially intra-gender redistribution, or the effects of recognizing the reproductive labor of wives for other women. So feminist legal realists like Janet Halley, Kerry Rittich, and Hila Shamir have shown how the exceptional status of the family as a legal category performs concrete distributional work. So their starting point is to highlight the significance of background legal rules, which influence the bargaining power of any social actor in a given situation. Similarly, they demonstrate the unintended consequences of legal rule changes, so that, in fact, an accommodation within employment law for working families, which is meant to recognize care responsibilities, can, in fact, end up consolidating and entrenching class and gender disparities, while ignoring protections for the secondary labor market of migrant care workers who support working parents. Mary Ann Case has also provocatively written about the intragender effects of increased employer responsibility for children. Also, besides this, the critique is that the law's recognition of female reproductive labor is so narrow that it normalizes heterosexual marriage to the exclusion of other organizational forms for the provision of social reproduction. So one could easily think of, the high value which is placed on non-financial contributions to a marriage, but it's not available within cohabitation law. And as you go on to LGBT families or caregiving relationships, which are non-couple oriented, then in fact the recognition is even less. So my intervention in this debate is to argue that feminists have worked very hard, feminist economists, development theorists, and legal scholars have worked very hard to redraw what in economic terms is the production boundary of the way that we value care in society. But in fact, I argue that a lot of these efforts end up discussing predominantly the predicament of married mothers in long-term marriages and at the point of exit. So how do we recognize social reproduction at the point of divorce? But what is perplexing is that despite these feminist critiques of mainstream economic theory, feminists' own conceptualization of the production boundary is somewhat limited. So the focus on social reproduction is very much around unpaid reproductive labor, which is performed in a relational context. So that even the vocabulary for the recognition of such social reproduction is articulated in terms of care work, caregiving, familial care, and unpaid caregiving. So what is absent here is an understanding of reproductive labor performed by women for the market in terms of social reproduction. So admittedly, there are very serious concerns about the exploitation that the commodification of women's reproductive labor might bring. Yet the widespread nature of such labor necessitates, at the very least, some feminist critique of whether the market values and compensates women's labor appropriately, and whether, in fact, there is any normative feminist justification for treating these markets exceptionally in relation to other sides of women's labor. And so my sense is that conceptualizing women's reproductive labor as performed for the family or the market in terms of a continuum is not altogether a theoretical exercise. And I think this is quite important for thinking about how to eliminate or at any rate reduce women's poverty. So any empirical exercise will immediately reveal that we can actually conceptualize marriage and market-based forms of reproductive labor through three lenses. So one is you could think of the relationship between the market and the family in terms of an overlap. Right? So these are real-life categories of women that I have encountered, certainly in my fieldwork, of the housewife sex worker, of the surrogate housewife. Right? So they're managing both forms of reproductive labor for quite different economies. The law is littered with reminders of this interconnectedness. So in the context of surrogacy, for instance, if you look at the Indian law on this, the Indian Council of Medical Research guidelines insists on referring to the legitimacy of the baby born out of the surrogacy agreement, so as to keep it aside from any implications for the marital arrangement. Similarly, you could think of the relationship between marriage and the market in terms of a continuum, which is that 74% of the women, of the sex workers in Sonagachi, where I did my field work, had been wives at some point. So they had transitioned from marriage to sex work. And this is the same with exotic dancers, certainly in the Indian context. Similarly, one comes across surrogate mothers who are housewives, who are actually earning money through the market to then exit their marriages. So there's a continuum between these institutional locations. And the third lens through which to consider these interests are through bargains. So actually, you could, and popular culture is replete with images of this, of the housewife's interest being conflicted with that of the sex worker, similarly of the surrogate vis-a-vis the commissioning mother, and so on, right? So interestingly, the distinctions that delineate marriage from non-marital economies of reproductive labor also affect economies at the abject end of the spectrum, despite striking similarities, both economic and social, of these rather abject labor sectors. So let me give you an example. So often, in the context of law reform, the recognition of one form of reproductive labor can result in a zero-sum game. So let me give you the example of exotic dancing in the Indian context. So when the Bombay High Court upheld the rights of dancers in Bombay's bars to, they reinforced their constitutional right to livelihood, they could do it only on the basis of a sharp distinction from sex work. So they said, dancing is res commercium, whereas sex work is res extra commercium. So it seems that despite the interrelated nature of these economies, actually, a change in rules in any one sector could affect women in related sectors. Moving on to how should we, visualize this from a post-colonial perspective. So I'm aware that we don't have a lot of time, but I just want to say that the typical response, the typical post-colonial feminist response to many of the regulatory impulses in relation to these sectors is one of highlighting the agency of the third world woman, right? So a lot of these forms of labor are highly socially stigmatized. So criminal law is a very popular response to these sectors, whether it's dancing or sex work. And that's fueled by the particular interests of Western states like the US. There are many stories of sexual humanitarianism in this context. Feminists, on the other hand, obviously are quite deeply conflicted over the question of exploitation, right? But I argue that the post-colonial feminist response simply to say, well, these women have agency is crucial, but it's fundamentally inadequate. So I think we actually need an entirely new vocabulary where every received concept, whether from post-colonial theory or feminist theory, is scrutinized, developed, or simply discarded. So I had a section here in my presentation on the relationship between feminist theory and post-colonial theory, simply with a view to bringing to the audience some of the sort of innovations from Indian post-colonial theory. But I think I won't necessarily go into it in much detail, except to say that I see one similarity between the Indian context and the Brazilian context, and that's in relation to the emergence, the institutionalization and the mainstreaming of gender discourse in state institutions, leading to the rise of what I think of as state feminism. And I think that feminist demands are finding increasing traction within many of these states, leading to what some of us have called governance feminism. So I think if one were to begin to compare the Indian and the Brazilian context, one might find an extraordinary resort to the criminal law through a raft of laws on domestic violence, rape, sexual harassment, sexual violence against children, and so on, all in the interest of gender equality. So here is somewhere I think there is scope for some comparative work. There are other interesting post-colonial contributions to the visualization of spaces of resistance, which again I won't go into, but I'm happy to clarify in the Q&A. So I guess what I'll end with is really articulate a little more the materialist feminist dimension of thinking about social reproduction. And I think there's a very rich materialist feminist tradition which is internal to feminist thought that we could draw on. And ironically, the post-colonial context is also one where the Marxist tradition is the strongest. So I think this is always a tricky space for feminists to inhabit. I think the added predicament also, and I wonder if it's true for the Brazilian context, it's certainly true for the Indian context, is that materialist feminists, unlike radical feminists, have a rather ambivalent relationship with the law and with law reform. So I think this is, again, something that we need to think about and elaborate on. Yet I think feminist scholarship on the political economy of these various sectors of reproductive labor, whether it is sex work or domestic work, is steadily growing. And I think it's only by through this materialist feminist turn and a robust accounting of the political economy and the socioeconomic institutional arrangements of these sectors that post-colonial feminists can really give meaning to the notion of women's agency. So I'll try to translate some of these insights for lawyers by suggesting that the turn to the political economy is best undertaken by a legal ethnographic method. And I'll just argue that there are 4 reasons why feminists might want to consider pursuing legal ethnography. The first is that actually a legal ethnographic method is quite crucial to mapping women's reproductive labor in sex work, domestic work, and commercial surrogacy, because these are actually part of transnational economic phenomena that are rapidly evolving and involve fairly complicated global service chains. So the transnational political economy of migrant domestic work, for instance, is very well studied, but flows can also go in the opposite direction. And here I'm thinking of my work on commercial surrogacy, where we have a phenomenon of reproductive tourism, where reproductive labor can be physically outsourced to a developing world location, and where the economy and its labors can offer maximum flexibility. And this is to the point where during my pilot studies in surrogacy clinics in India, C-sections were performed on the surrogate mothers just in time so that the commissioning parents could manage their flights into India, take the baby, and the paperwork is all streamlined by then and could exit, right? So it's a very high level of efficiency within this market. So I think this can only be unearthed through empirical work of some sort. The second reason for looking at legal ethnography is that feminist legal scholars for very long have been using this legal realist impulse, which is to say the action is not really in family law, it's a labor law or a welfare law or something else, right? That's a very familiar move for us. But I think that context is quite crucial. So although feminist legal realist analysis can tell you what other rules to look at, it doesn't tell you which ones you should focus on. Okay, and this you can get only by doing some basic fieldwork. So let me give you an example, and this is based on my work on sex work in Sonagachi, which is a very large red light area in India. It became very clear, so it was very clear from the beginning that the criminal law had no effect, right? There were all sorts of ways in which people in the red light area were sidelining the criminal law. But what was interesting was actually that it was the state's rent control laws and its tenancy rules in that red light area that were determining where different sex workers in that political economy of the red light area were actually leveraging their economic power, right? And actually there's, as far as I know, I hadn't encountered any sociological or legal account of sex work in these terms. And so I think only ethnographic work can tell us what are the salient legal rules to focus on. And we need this because we are now increasingly approaching law in a legal pluralist fashion, right? It's not simply the formal state law, but the layers of small bore rules which govern the household or pathways or social norms and market practices. The third reason for using a legal ethnographic method is to problematize the centrality of gender, and I think this has come up in the morning session as well. And I think actually it turns out that a lot of these reproductive laborers, you can't actually find that there's anything like women's interests that we can further on the whole. It turns out that there are deep contestations between different categories of women. So in the care work debates, it would be between the nanny, au pair, housekeeper, and the wife, who all have very, very different legal endowments. And certainly in the sex work debates, there is no one category of sex worker. They are all vastly internally differentiated. And the fourth reason for using legal ethnography is to predict the unintended consequences of well-meaning legal reforms. And so one can, it's an easy argument to critique the increased use of criminal law by radical feminists, right? And they're really quite powerful and influential in terms of whether it's sex work or trafficking, you name it, the criminal law is there, and we can predict quite easily the unintended and negative consequences of criminal law moves. But I think one could easily apply that counterintuitive economic analysis to quote-unquote progressive proposals for law reform. So for example, when I looked at labor law proposals in Sonagachi, this red light area, I actually found that no matter which legal proposal I tried out and performed an economic analysis, the one consistent group that benefited was the landlords in that neighborhood, right? So I think a very fine-grained economic analysis can show that both the move towards criminal law and labor law could actually hurt certain categories of women. So I think I'll simply end by, actually one other example which I'd like to share is in the homemaker and the care work debates, studies have shown that the more secure a home worker is in the post-divorce scenario, the more likely she is to stay at home. So actually you can find legal regimes that protect homemakers well upon divorce can also produce the highest incidence of a traditional sexual division of labor. Right, so it's precisely to measure some of these counterintuitive consequences of regulation that I think feminist ethnographies and legal ethnographies, because the ethnographers don't understand the law in the way that we do, and feminist lawyers don't necessarily undertake ethnography. So I think there's room for a productive conversation here. So in conclusion, I just want to say that empirical work does not resolve some of these fundamentally political arguments that we as feminists have around women's labor. And it may well turn out that actually legal ethnography mystifies the impact of the law rather than demystifies it, right? And in fact, we might end up with some very narrow proposal for law reform at the end of all that work, rather than what sort of bold political ambitions that we might have. But I think these risks are still minor compared to the rich insights that this kind of feminist work can bring to debates on social reproduction. Thank you.